Hello everyone. So in this video we are going to discuss Office of Chief Minister. Prior to this, as part of our discussion on part 6 of Indian Constitution that deals with the state, prior to this we already have covered Governors chapter where we had detailed discussion. We had spent around more than 3.5 hours on the discussion on Office of Governor. So I hope those videos you already have watched. Right now we are going to discuss Office of Chief Minister. So let us see what is the scope of this video. So first we will discuss the structure of state government. If you remember, structure of state government has been discussed in part 6 of Indian Constitution. So prior to this we have covered part 5 of Indian Constitution that deals with union government. Then part 4 of Indian Constitution has also been discussed that dealt with DPSP, part 3 fundamental right, part 2 citizenship, part 1 union and territory. So all the chapters has been discussed in detail. Now we are into the states, that is part 6 of Indian Constitution. So first we will discuss the structure of Indian state government, that what structure we already have covered so far and what structure we are supposed to cover in this part of Constitution. Then we will discuss process of invitation. So once election result has been announced, what factor goes into play, what factor decide that which party is to be invited to form the government by the governor. And then we will discuss the appointment method, that who is the appointing authority, what oath does chief minister does take, what is this floor test of the CM, how time is allocated, how much is the reasonable time, how is the Supreme Court's interference if arbitrary time is allotted to the chief minister or a particular party by the governor. Then CM's power with respect to chief minister's power with respect to governor, with respect to his own cabinet colleagues, with respect to assembly, what are the power that chief minister does enjoy. And as always, as has been our tradition, that we put up 4 or 5 relevant MCQ relevant to our discussion, right? So that is going to be the pattern of this video. Now without wasting time, let us enter into next slide and let us discuss the structure of state government. So this structure we had discussed in the governor chapter as well, right? So part 6 of Indian Constitution that spans from article 151 to article 237, part 6 of Indian Constitution has been divided into 6 chapters that you could see on the screen. So the first chapter that has where only one article has been dedicated that deals with general information regarding the state. Then you have second chapter that deals with the executive, and as part of executive there are 3 offices, that is governor's office, then council of minister. In council of minister you have chief minister, and another chapter is dedicated to the council of minister, right? And then you have advocate general. So these 3 structures together forms the part of executive. Then the third chapter deals with the state legislature, and the state legislature consists of legislative council and legislative assembly. Then the fourth chapter, if you can see on the screen, the fourth chapter deals with the ordinance making power of the governor, where you have this only one article, article 213, that has been dedicated. Then you have this fifth chapter which deals with high court. The corresponding chapter in the central government, if you remember, you had this Supreme Court. And then you have sixth chapter that deals with subordinate court, again the corresponding structure at the central level were dealing with CAG, right? So this is about the structure of part 6 of Indian Constitution, or structure of the state. I hope the structuring you would have understood. So we are right now here, right? So council of minister, as part of council of minister we are discussing chief minister. In the second lecture would be on council of minister. This advocate general will discuss when we will discuss the constitutional bodies, thereafter state legislature and so on. So I hope the structure of this state government you would have understood. Now we are going to discuss the position of chief minister in the parliamentary system, and why it has been put up parliamentary system, because the position that is being enjoyed by the prime minister, or the power that is being enjoyed by the prime minister at the central level with respect to the president, similar amount of power is enjoyed by the chief minister in this, because we are following this parliamentary system at the central level as well as state level, right? And I'm not going to explain you that why this is called president is called head of state, why he is called head of government, why he is called de jure head, why he is called de facto head, why he is being called just ceremonial, nominal or titular head. This has already been explained an umpteen number of times when we were discussing the president lecture, when we discussed this prime minister lecture, when we discussed chapter related to governor. So wide amount of discussion has gone into the explanation of all these wordings, right? So I'm not explaining you. The only thing that you have to do is that you have to replace these two images. So president will be replaced with the governor and prime minister will be replaced with chief minister. All the headings, all these words that describes the position of chief minister in parliamentary system, or that was dealing with the prime minister's power with respect to the president, all these words will remain same. Governor will be called head of state, he will be head of government, he will be called de facto head, he will be called de jure head, symbolic power, title, all those details. He will be possessing real power, he will be possessing just nominal power. So all these things, I hope the detailing is not needed, at least in this chapter, considering that I already have issued the caveat that before coming into the corresponding lectures of the state government, you have to attend the lectures, or you have to watch those lectures that we have covered in the parliamentary system, right? So with respect to when we are covering this chief minister's chapter, I presume, and that is rather a prerequisite, that you would have already watched the lecture related to the prime minister. So with that declaration, we are moving to the next lecture, and let us discuss that who can become chief minister. So in this portion on this slide, we are raising two questions. The first question is that can a non-member, means a member or a person who is not member of legislative assembly, who has not been chosen, he does not belong to any house. So there are 22 states in India, rather 6 states in India which does have upper house. So suppose a person who is neither member of legislative assembly nor member of this legislative council, can he be appointed chief minister by the governor? So that is the first question. The second question is that can a person belonging to the upper house, that is legislative council, be appointed as chief minister? So answer to both the question that we have raised is yes, that yes, a member who, or a person who is neither member of legislative council nor member of this legislative assembly, means a person who is not member of lower house and not member of this upper house, he or she can be appointed chief minister. There is a star attached to this point, right? We'll discuss what is the condition that is attached. But if any person like me or you can be appointed, if a political party agrees that a person is suitable, then even if that person is not member of legislative assembly or member of legislative council, even then that person can be appointed as chief minister by the governor on the recommendation of the party which does enjoy majority on the house. So that was the answer of the first question. The second question was that can a person belonging to the upper house become chief minister? So the answer to that question is also yes. So we do have two examples in recent history. You have two major states. The first state is UP and the second state is Maharashtra. So in Maharashtra, Shiv Sena chief Uddhav Thackeray, he was not neither member of legislative, means he has not contested election. This was the perhaps first time that he has, or he has not gone into the election either, right? Right now he has been nominated from the legislative council. So at the time of being swearing in at chief minister, he was not member of legislative assembly, right? So that was the answer to the second question, that yes, can a member who is not member of legislative assembly, can he be appointed? So answer is yes, that he can be appointed. Here are two cases. So even in case of Uttar Pradesh, at the time of being swearing in, just prior, means he had resigned, but prior to being sworn in, immediately prior to being sworn in, he was member of parliament, not member. Under condition for being sworn in as chief minister in any state is that that person should be MLA, right? So he was MP. As a MP he resigned, and thereafter he was sworn in as chief minister, and the star condition, and thereafter, the star condition that I was talking about, the star condition that has been mentioned in Article 164, that a person who is neither member of Legislative Assembly nor member of Legislative Council, he or she can be appointed Chief Minister, or any of the, for that matter, he can be appointed. Any same condition applies. The condition that I am going to state right now, same condition is applicable for a person to be appointed Council of Minister as well. So a person, if a person is not member of either house of the house, that is Legislative Assembly or Legislative Council, he can be appointed Council of Minister as well. The only condition that is attached with it, that person who has been appointed or who has been sworn in as Chief Minister or Cabinet Minister, he has to get himself elected or nominated in through the Legislative Council within the 6 months period. So this is the only condition, that a person, if he has been appointed either Council of Minister or either CM, he has to get himself either elected in the Legislative Assembly. In the assembly he will have to get himself elected, or in the Legislative Council, right, as a MLC, again either he has to himself get elected or nominated, right. So he'll have to himself registered either as a MLA or MLC within this 6 months of time that has been mentioned in Article 164. So these two people who are neither this MLA, the first condition, and they are from upper house, later on within 6 months they have ensured that they enter, means they are Yogi Adityanath also, he is a MLC, and this person Uddhav Thackeray, right, he was recently nominated from this upper house, that is Legislative Council of Maharashtra, by the governor. There was huge amount of controversy that was surrounded on his nomination as well, but finally he has been nominated, right. So I hope these 3 points you would have understood. Now, is there any eligibility criteria that is mentioned in the Constitution if a person has to be appointed as Chief Minister or Cabinet Minister? No, answer is no. There is no eligibility criteria that has been mentioned in the Constitution. The only condition or only situation that they needs to fulfill if a person has to be appointed either Chief Minister or Cabinet Minister, the only criteria, and that too has not been mentioned in the Constitution, that is just we have deduced it from somewhere. The only criteria that they needs to fulfill is that they should be eligible to become MLA. Not necessarily, means they should not even be MLA, they should be eligible to become MLA, member of Legislative Assembly or member of Legislative Council. So that is the only condition that they needs to fulfill. They needs to be eligible to become MLA, right, and thereafter they have been sworn in within 6 months, they should be elected or nominated to any of the house of the state legislature. I hope who can become Chief Minister would have been responded. Now we are moving to next slide. So now we are going to discuss the process of formation of the government, right, how any party is invited to form the government. So you have this governor who is supposed to invite. So election has happened, election result has been announced. Now it is the duty of governor to invite any party. Now which party will be invited? So that is called the process of invitation. So see, there can be two situations. The first situation could be this and the second situation could be this. What is this first situation? So suppose election has happened and there is one particular party or one pre-poll alliance that has ensured that they get clear-cut majority. So suppose I am again taking example of Maharashtra, right. So in Maharashtra the Legislative Assembly size is 288, and if a particular party or two party which has been in pre-poll alliance, they have ensured, they have collectively, or BJP single-handedly or any particular party has single-handedly won this 145 seats. So in that situation there is no problem. So that will lie into the first situation, and in such situation where a particular party or a pre-poll alliance has secured clear-cut majority, in that situation governor will have no problem or will have no options but to invite that particular party, or to invite that pre-poll alliance, and their leader of that particular party which has secured the clear-cut majority, their leader will be sworn in chief minister, and on the advice of chief minister you will have cabinet minister, right? So there is no problem in that situation. But there can be second situation. So second situation could be something like this, that the election happened, election result was announced, and here in this assembly where this number was of seat was necessary or required majority, this was the number, and the fractured mandate that the other parties have got, this is like this. So you have this BJP which has secured 105, Shiv Sena, so no party, clearly you can see that the majority mark was 145, no party has been able to secure the majority. It is a fractured mandate. In that case, what options that governor? So here it is this situation, and it is in this situation where different parties does have fractured mandate. In that situation, governor does have discretionary power, and it is here that all objectionable power of the governor comes into the play, right? So the established political convention dictates that the leader of single largest party will be called. Thereafter, if that single largest party is not able to form the government, or if they say that no, we cannot form the government, thereafter the second largest party, thereafter third largest party, thereafter the fourth largest party, means in this sequence they will be called by the governor. And that is again these sequential manner that I am talking about, it is not mentioned in the constitution. Rather, it is not mentioned in the constitution that who should be appointed chief minister. That process has not been mentioned. So governor, it will completely depend on the governor's wisdom that who he is going to call. So he can totally ignore this single largest party, and if in his opinion, if he is of opinion that this particular party does have ability, that they can cobble up numbers, they can get the number, they can associate with other parties, and they can form the government, and they can form the government in a stable manner for next 5 years, right? So in that situation, they can ignore the governor can ignore the single largest party, and he can call directly the second, or rather third largest party, let me tell you, right? So it is the discretionary, completely the discretionary, and the same situation you had at the central level as well. So I hope this point you would have understood, and the discretionary power of the governor, in which situation that discretionary powers comes into the picture, discretionary power of the governor also you would have understood. But let me tell you that until 1980s or 1990, if you remember in the governors chapter, we had discussed union judiciary's phase. So union judiciary or the high court, or rather judiciary overall, has gone through different phases, right? So you had this submissive judiciary phase, then you have this passive judiciary phase, and then you have the third stage where we are in, you have this age of active judiciary right now, right? So until 1990 or 2000, right, governor's wisdom, whatever governor said, it would be rather followed. But now whenever governor exercises, because political environment nowadays is very vitiated, and the governors act most of the time is tilted towards the ruling party in the center. So as soon the governors act in an arbitrary manner, the cases generally lands into the Supreme Court by the parties who are not dissatisfied, right? So here when I say that the governor can, if in governor's opinion this particular party, that is second largest party or third largest party, if in his opinion this third largest party is in situation to give the stable government to the state, he can call this party to form the government. But this decision that he is taking, or the wisdom that he is exercising, that should not be dictated by his arbitrariness, let me tell you. Because if that is arbitrary, if he is acting in an arbitrary manner, if he is acting in unjust manner, rest assured, if he has ignored the first this single largest party, and if he is calling another party, rest assured that this party is going, means if this party does have any amount of possibility that by cobbling up number with independents, right, they could have managed to form the government, and if governor under the political consideration by ignoring this particular party has called this party citing that I do have discretionary power, rest assured that that case will get into the Supreme Court or High Court and Supreme Court. So the discretionary power that we are talking about, right, the discretionary power is being continuously curtailed by the active judiciary that you do have right now, right. So although the discretionary power is being held by the governor, but the right now means from last 10 years when the judiciary has become very active, you will see most of the discretionary power, although constitutionally governor does have wide amount of discretion, but that wide amount of discretion is continuously being curtailed. So every arbitrary decision, every unjust decision, every decision that is tilted towards the ruling party in the center of the governor, every that decision of the governor is landing into the Supreme Court, and Supreme Court is giving completely the decision that is most of the time contrary to the decision, or most of the time the contrary to the wisdom of the governor. I hope the points you would have understood, right. So what sequence generally would be followed, right, and what should be followed, you would have understood. First single largest party, then another next single largest party, then third largest party, then fourth. So this should be order, this should be the order, but governor does have discretionary power, right, through this established political that he can, in his opinion, if he thinks that this party does have number, can manage the number, then this party can be ignored irrespective of what decision Supreme Court is giving. Irrespective of that decision, right, he can exercise the discretion, right. Supreme Court cannot cannot proactively come into the rescue that, hey, why are you ignoring this particular party, why you are, means it is only when this particular party will go into the Supreme Court, then Supreme Court will get into this decision. I hope that point you would have understood, right. Now let us discuss the next point, and the next point is, just a moment, leader of the party which has secured highest number of the seat, right, in the second situation. The first situation where a particular party had clear majority, their leader will be asked to form the government, and CM and cabinet minister will be sworn in. But in second situation when when no party had the clear majority, in that case leader of the party which has secured highest number of the seat, right, BJP 105 seats, right, they will be called in, or governor can also invite a party which he thinks can manage majority and run a stable government. So that should be the determining criteria. When governor is exercising his discretion, he should be guided by this stability of the government, that which government or which party is most suitable to give the stable government to the state, right. So governorial discretion, exercise of this discretion of the governor while inviting parties should be guided by the stability of the government, right, suggested to put thereafter once chief minister. So suppose, see, if a particular party did have clear majority, in that case they generally are not asked to prove the majority. But if there were 2 or 3 parties which collectively came together and they have formed the government, in that case what will happen, leader of that particular party or leader of these 2-3 parties, whichever leader that they have come up, their leader will be sworn in as chief minister, plus few cabinet minister as well will be sworn in, and thereafter they will be given some time, some reasonable time, right. It could be 2-4 days, at times in the past it has been 30 days as well, as long as 30 days as well. So whatever in governor's opinion, again here, that how many number of days should be given, again that entirely depends on the discretion of governor. So there have been instances 10 or 15 years ago where 30 days time has also been given to those sworn in chief minister, to those council of minister, that within 30 days you have to prove the majority. But nowadays this period is continuously reducing, right. Generally 4 or 5 days are given to prove the majority, and thereafter if they are not able to prove the majority, then that council of minister will collapse. You had recent example in 2018 in Karnataka government formation, where a particular party had been given 15 days of time. And let me tell you, the political situation was such. So you had here, BJP had formed the government. BJP's Chief Minister Yedurappa ji was sworn in as Chief Minister, and Governor had given 15 days of time. Now the situation, political situation was such that JDS plus Congress, INC combined had the majority numbers, whatever number that is. These people did not have the majority. They had perhaps 105 seats. I guess I don't exactly remember, but they were falling short of 14-15 seats. Now this 14-15 seats could not have been managed without any defection from this party, either JDS or Indian National Congress, right? Even if there were 4 or 5 candidates, independent candidates, if they would also have come, right, they were not able to manage this 14 or 15 additional numbers. So the only situation in which BJP could have the required number or the majority mark when there were defections from the JDS and INC, right? So this was, means if this was the situation, Governor himself should not have given 15 days, because if you are giving 15 days in a situation where without political defection from these two parties, government cannot be formed, or floor test this particular party cannot pass, right? So 15 days time should not be given, because ultimately in this situation, as a governor, what you are promoting is, you are promoting something called horse trading that we have discussed in Governor's chapter as well, and that is not an ethical thing to do, because governor generally they are of 60-65 years or 50 years, so they do have that level of understanding. And if they are giving this much time to a party which cannot manage number except by this political defection, so ultimately you are supporting that political defection from another party, you are supporting that horse trading. So a logical person, honest person holding this constitutional post should not give this much amount. Finally JDS and INC combined went to the Supreme Court. They presented their case that, hey Supreme Court, we do have this number, we do have majority mark, and when we do have more than half of the seats in the assembly, how can this person manage the majority even except by this political defection? So Supreme Court understood the matter. They gave finally 24, after hearing to their cases JDS and INC, Supreme Court suggested Yedurappa to prove the majority within 24 hours, and finally they could not prove the majority, and their Council of Ministers, means prior to even moving the confidence motion, they resigned, right? So although the example that I had taken, the 20-30 years ago, this 30 days time that was being given to different police, they were justified, but this active judiciary nowadays, whenever this governor is exercising any discretionary power that is unjust, in this case the 15 days time, considering the political situation in the case, right, 15 days time was unjust, was completely arbitrary, was promoting horse, was about to promote horse trading. So Supreme Court intervened, and this 15 days time was reduced to 24 hours. Right. So suggested to prove the majority means after being sworn in as Chief Minister and Cabinet Minister, that particular party will be suggested that, hey, you go to the house, you prove your majority, right? Prove majority in a reasonable time allotted by the governor. Time allotted depends entirely on the governor's discretion. However, every unreasonable case is nowadays ending in Supreme Court. So this point also you would have understood. Now we are moving to the next slide. Okay, so here this point, just a moment, that constitution does not require Chief Minister to prove majority before being sworn in as Chief Minister. So whosoever, in case, see, in the previous case we already have discussed that in case none of the party has secured the majority, right? If any party has secured the majority, fine and good, right? But if no party has secured the majority, then governor discretionary power is to the extent that he can call this INC, which has lowest number in the assembly, and he can ask them to choose their leader, and their leader can be appointed as Chief Minister because of this provision, because in constitution it has not been mentioned that which person will or should be appointed as chief minister. It is only after that person has been appointed chief minister he will be asked to prove the go to the house and prove the majority. It is only up. So effectively, if governor's discretion is to be exercised, and if that case does not land into the Supreme Court, means Supreme Court does not intervene, so effectively governor's discretion is to the extent that he can appoint any person as chief minister, and he can remain chief minister for the number of days that the governor has given him or her to prove the majority, and thereafter only on the house it will be decided that they do not have that number, right? So that is the extent of the governor's discretionary power. So but the only rider is that the governor's discretionary powers comes into the picture only in this situation when no party does have clear-cut majority. I hope this point you would have understood. We have spent enough time on this portion. Now, what is the process of appointment of chief minister? So that is mentioned in Article 164. Article 163 we already have seen, right? Now we are discussing this Article 164 from chief minister's point of view. So who will be appointing chief minister? So chief minister will be appointed by the governor. So governor is going to be the appointing authority, and governor is appointing authority not only for the chief minister, but he is appointing authority for other minister, cabinet minister as well. Other cabinet minister will be appointed. So how other cabinet ministers are appointed? So chief minister office, CMO, or chief minister elect, CM elect. I hope you know the difference between CM and CM elect. This word we had used in prime minister lecture as well. There is something called PM and PM elect, right? So CM elect forwards the name of 4, 5 or 10 person, whosoever he wants to be sworn in as cabinet minister. So chief minister elect will forward name of 7, 8 depending on the political situation, will forward that, hey governor, I want these people to be appointed as my cabinet minister, right? So on the basis of that recommendation, on the basis of those names, right, those people will be appointed as cabinet, those people will be sworn in as cabinet minister by the governor. Now the question can be raised that can governor suggest any changes on the names that has been sent by the chief minister elect? Answer is no. Governor in that respect does hold no power. He cannot ask or he cannot suggest chief minister elect to edit some names, to add or delete some names. That provision, that is completely prerogative of chief minister. So chief minister has prerogative to decide his cabinet colleagues. Governor is just appointing authority in that regard. Before a minister enters upon the office, governor shall administer to him oath of office and oath of secrecy. So there are two oaths that is being taken by cabinet minister. Cabinet minister and chief minister, there are two kind of oath. Oath of office and oath of secrecy. Why this oath of secrecy? Because he is entering into the important office. This oath of office, oath of secrecy, although has been put up in detail on the next slide, but I'll not discuss it, considering again assuming that you would have watched this prime minister lecture where we had discussed this oath of office and oath of secrecy in very detail. We have spent only on oath around 10 minutes of time, so I'll not spend the time here, right? Oath of office and not. So when this cabinet minister, when they are being administered oath by the governor, they are sworn in as cabinet minister or what you call a minister of state, right? They are not being sworn in as minister of a particular ministry, right? So no minister will be at time of being swearing in, right? So no minister during swearing in is going to swear that, hey, I as so and so is being appointed as agriculture minister or minister of science and technology or minister of education. No, they are just, their oath is administered just as a cabinet minister or minister of oath. The portfolio distribution, that which particular minister or which particular cabinet minister will be awarded or will be conferred this educational ministry, science and technology, textiles, so all that will be done on a later stage by chief minister at the state level and prime minister at the central level. So it is the portfolio allocation as far as concerned, that portfolio allocation will be done by chief minister, not by the governor. So oath of office and not, when they are taking oath, they are taking oath of the office and not particular ministry. So I as ABCDEF takes oath of Ministry of Science and Technology. No, that's why this is strike through. Portfolio allocation is done by Chief Minister later on the basis of seniority and other political consideration. I hope these points you would have understood. Now we are entering into the next slide. So oath of office, two kind of oath that a person who is being sworn in as cabinet minister. So two kind of oath he takes, one oath of office and another oath of secrecy. So this is the content of oath of office and another oath of secrecy. Content of oath of secrecy is this, right? So I am not going to explain this again with the same direction, assuming that you would have watched that Prime Minister's lecture. Now, so once they have been appointed, they will be asked, they will be suggested to face the floor test into the assembly. So the first business, so first swearing will happen, swearing in. Once they have been sworn in as cabinet minister and chief minister, thereafter they'll come into the house. First they'll take oath as member of Legislative Assembly, and immediately after that there will be floor test, right? But there is one peculiar situation, and that situation is that if one party or a pre-poll alliance has clearly won the majority, they had that half of the number. So Maharashtra example, if I take, you had this 145, so whichever party had secured 145, they'll have a clear majority in the house size of 288. So if there is one particular party which has secured this number and their leader has been appointed chief minister, in that case generally this floor test does not happen. I am saying generally, not always, right? So be at central level or be at state level, if a particular party has secured clear-cut majority, in that case that party will not have to face this floor test in Lok Sabha or assembly at the state level, because they already have clear majority, right? But if their majority is questioned by the opposition party, only in that situation they can be asked by the president at the central level and governor at the state level that okay, go and face the house, obtain the confidence of the house, and they'll have no issues at all generally, even by opposition party, because they already know that these people does have majority. So that will, if we insist on holding this floor test, in that case it will lead ultimately eventually to our embarrassment. So generally this opposition party is also wise in that taking the decision that they do not question the majority if a particular party has single-handedly obtained the majority. This floor test most of the time happens only, not most of the time, it will be always, right? Floor test always happens in the cases where you have more than one party which have come together post poll, right? Or there has been 2, 3 parties, 4 parties along with few independents, right? It is only in that situation that governor at the state level will suggest that hey, go to the house and obtain the obtain the confidence of the house. In case if they manage the majority, if they get the confidence of the house, thereafter then their government will continue. If they do not get the confidence of the house, means if more than half of the number of the members of Legislative Assembly do not support them, in that case whole of the Council of Ministers which was just being sworn in, right, just was sworn in by governor, they will have to resign. I hope this point you will have understood. This vote of confidence is separate from no confidence motion. So there are two kind of motion, confidence motion. So confidence motion is generally moved by the ruling party, right? So at any stage, if governor feels that the current incumbent government, so suppose a particular party had the majority and they had been running the government from last 2-3 years, now there has been few cases of defection from their party, 2-3 MLAs or 10 MLAs had defected to another party, and that has been published into the media, right? It is clearly to everybody, it is known that their member of Legislative Assembly has defected to another party, and by defection, but by that number of defection, this particular government has come into the minority, right? So in this case, either on the claim of opposition or governor at the state level suo motu also can ask that ruling party that hey, go to the house and seek the confidence of the house, right? So the vote of confidence, the difference between no confidence motion and vote of the confidence is motion of confidence is that this motion of confidence or vote of confidence is moved by the ruling party, and this no confidence motion generally is moved by the opposition party. So that is the difference. No confidence motion is moved against particular is not moved against a particular minister but against whole of the Council of Ministers. You can separate it from censure motion that we have studied in the Parliament. So censure motion can be moved against an individual minister as well, but this no confidence motion, when is moved, right, it is moved against whole of the Council of Ministers. I hope these differentiation and these points you would have understood. What is the term and salary? So see, as far as term is concerned, term of any Lok Sabha at the central level or assembly at state level, the term of assembly is supposed to be 5 years, right? Supposed to be 5 years, but it is not fixed, right? It can be increased in cases of emergency. If you remember when we had discussed this emergency chapter, so when you have this imposition of national emergency under Article 352, the term of assembly can be increased or it can be decreased as well. So suppose no party claims to form the government, right? So in the previous case, if you remember when we were taking the example of Maharashtra, here clearly no party had the majority. In the first instance, BJP was called in. BJP said that no, we cannot form the government. Shiv Sena, no. NCP, no. INC was not called in. President rule was imposed. After the president rule, so suppose in between, after the president rule had been imposed, right, in between the Shiv Sena, NCP and INC combined came to claim or came to stake the claim over the government formation. But if in between this time when president rule has been imposed, if for around 4 or 5 or 6 months maximum, right, if no party would have claimed the formation of the government, then in that case governor did have no option than to dissolve the assembly and call for a fresh election. So in situations like this, or the another situation can be where elected government which does enjoy the majority, if that elected government that is enjoying the majority, if they also suggest to the governor to dissolve the assembly, even in that case assembly can be dissolved prior to 5 years, right? So the situation that supposed term of assembly or Lok Sabha should be 5 years, and that has been envisioned in the constitution, that has been written in the constitution as well, that the term of Lok Sabha or the term of assembly should be 5 years. But as I told you that there are circumstances where the term can be increased, and there are political environment where term can be reduced as well from 5 years. So if government, if government which is in majority, if they suggest that it should be preponed, election should be preponed and assembly should be dissolved, in that case, or if no party forms the government, in that case as well it can be lower than, the term of assembly could be lower than 5 years. So they hold office. Other thing is that the term of MLA, if I talk about, or Council of Minister or Chief Minister, if I talk about, means what I was talking right now was the term of assembly or term of Lok Sabha I was talking about. If term of Council of Minister, if I talk about, right, including Chief Minister, they hold the office during pleasure of the governor, right? Here you do have this asterisk mark, star mark. So there should be something special, and the special is that, okay, the constitutionally spirit is that they should hold office during the pleasure of governor, but this does not mean that the governor, if at any time or at his whims and fancy, if governor says that no, I am removing my pleasure, you will have to resign. No, that will not be the case, right? So these people, Council of Ministers, will continue in the office, they will be part of government, they will be executive, as long as they do enjoy the confidence of the assembly, confidence of the lower house, that is legislative assembly. So as long as they do have confidence of the house, there is no meaning, this is just an article and it will not come into the picture. This pleasure of the governor comes into the picture only in certain circumstances, but not in the circumstance when this Council of Ministers does enjoy the confidence of the house. What do I mean does enjoy the confidence of the house? So as long as they do have majority in the lower house, legislative assembly, this pleasure of the governor won't work, and that's why this asterisk sign. Salary, as far as salary and allowances of chief minister or cabinet ministers are concerned, it is decided by the state legislature. When I am saying state legislature, in case of unicameral legislature, only by legislative assembly; in case of bicameral legislature, by legislative assembly and legislative council. So I hope this term and salary would also be clear to you. Now we are moving to the next slide to discuss position of chief minister, or you can also say the powers of chief minister. So we have categorized the powers of chief minister with respect to these three offices. So let us discuss that what is the power that chief minister does enjoy over the office of governor. Then his second category of power has been put up in this category, that what are the powers the chief minister does enjoy with respect to his own cabinet colleagues, and what is the power that chief minister does have with respect to the state legislature. So let us pick this one by one and let us start discussing the powers of chief minister or position of chief minister in the state, right? So let us pick this first point, that what is the power that chief minister does enjoy with respect to his own cabinet colleagues. So you have this article 164, and parallel to this article 164 at the central level you had this article 75. So if you remember when we were discussing the prime minister, so to the prime minister we had described him first among equals, or primus inter pares, and that is the same word that will describe chief minister as well. So when he is being called for, why he is being called first among equals? So see, try to understand. You have this council of minister, and all the council of minister is considered equal partners in this council of ministers thing, but chief minister has been granted first position among these equals. Now when he is being granted, when he is being said that he is first among equals, or he is the head of council of minister, there would be certain power, special power that would be granted to this chief minister at the state level and prime minister at the central level. So what are those special powers? So there are three special powers that chief minister at the central level has been granted under this article 164. So let us start discussing that what are those three special powers that chief minister does have with respect to his own cabinet colleagues. So see, all the ministers are appointed by the governor, there is no doubt, but how these are appointed, we already have discussed that they will be appointed, cabinet ministers will be appointed by advice of chief minister. So whatever file, whatever names are being sent by the chief minister to the governor, only those people can be appointed. Out of the MLA, only those people can be appointed cabinet ministers, right? So that is the first special power, and when they are being appointed on the advice of the chief minister by the governor, chief minister will also have right that he can also get them removed from the cabinet if he is not happy from the performance of any cabinet minister, right? If he is not happy with the functioning, then he can suggest governor that hey, you can remove the pleasure from this particular minister because he is not functioning properly. Rather, reason also need not to be cited. Many a times due to the political consideration, when you have more than three parties in the coalition, due to the political consideration as well, the cabinet reshuffling keeps happening, right? So on the either due to the performance issues or due to political reshuffling, there would be chances where a particular minister may be asked that hey, can you resign? And if he does not voluntarily resign, if that particular minister is adamant that I am not going to resign, in that case the last resort, as part of last resort, chief minister can suggest governor that hey governor, you remove this pleasure from this particular, and it is at that time that governor can withdraw the pleasure from that particular minister, and that particular minister will be terminated. But again, the pointer that first the chief minister will suggest that particular minister that hey, you resign. In case he is not resigning, only then this option will be resorted to. So the two parts with respect to his cabinet colleagues, CM's power, chief minister's power, you would have understood. The third power is that it is the job of chief minister to distribute the portfolio. So at the time of oath administration, if you remember, we already had discussed that at the time of oath administration, the council of ministers just take oath of minister as a minister, right? So this oath is not taken by like I am taking oath as a Ministry of Science or Technology, I am taking as oath as Minister of Agriculture. No, that portfolio distribution will happen at a later stage, and there are various interplays that happen. So on the level of seniority, on the level of another political consideration, that this portfolio distribution can be done. So it is completely the job of Chief Minister that what portfolio is granted to which minister. Again, the reason can be seniority, the reason can be political, or there may be other consideration, caste consideration, then a communal consideration, those religious considerations. All those consideration does play that which particular MLA is going to get which ministry. So I hope these three parts of the Chief Minister with respect to his own colleagues you would have understood. These two are additional points, that Council of Ministers works on the phenomena of swim and sink. What is the meaning of swim and sink together? So the meaning is that if Chief Minister resigns from his office, so it is not the Chief Minister alone. See, Council of Ministers cannot function without this Chief Minister. So if Chief Minister has resigned, whole of the Council of Ministers is going to collapse, right? So if the Chief Minister is resigning, it is not alone that he is resigning, he will be resigning on the behalf of whole of Council of Ministers. So in that case, whole of the Council of Ministers need not to tender the resignation if Chief Minister is going to tender the resignation. I hope this point of swim and sink together. Now you can add one another point, that okay, fine, if Chief Minister is resigning or if Chief Minister is not there, you said that this Council of Ministers cannot function, right? Another situation can be, what if this Chief Minister unfortunately dies in the office? While being in office, a CM can die. So generally at this point we had discussed again in the Prime Minister chapter as well, that if Chief Minister is dying in the office and that particular party does have clear majority, in that case governor, this COM is not going to collapse. This COM in that situation will not collapse. In that case, governor can do is that he can pick up any senior minister of the cabinet and he can be appointed acting chief minister for the time being, and as soon that particular party comes up with their own leader, right, as soon they comes up with their own leader, thereafter particular person will be replaced with this acting chief minister. If the party, that particular party comes up quickly with the chief ministerial berth or chooses their leader, in that case governor will have no issues. Instead of acting chief minister, he'll directly appoint that particular minister as a regular chief minister. I hope these points would be clear, and the first category of Chief Minister's power with respect to the cabinet colleagues would be clear to you. Now we are moving to the next slide to discuss the powers of Chief Minister or the relationship of the Chief Minister with respect to the governor. So there are three articles in which relationship of governor with respect to Chief Minister has been defined. So you have this article 163, article 164 and article 163, where you can study the relationship of Chief Minister with respect to governor. So here, if you remember, at the central level you have this corresponding article, article 74, article 75 and article 78. So what is the content of this article 74, article 163, article 164 and article 167? So in article 163 it is said that there shall be a council of minister, right? If you remember the image, so you had these 3 or 4 ministers. So there shall be a council of minister with chief minister as its head to aid and advise this governor. So that was one relation that was defined in article 163. Let me repeat it. So there shall always be council of minister with chief minister as its head to aid and advise this governor in his exercise of executive function. So that was the one article. Then article 164, similarly article 75 at the central level, it says, article 164 says that these people, council of minister including chief minister, will be appointed by this governor. So that was article 164. Similarly article 75 had similar language for the central level, that PM and cabinet minister will be appointed by the president. The word will be replaced, right? And then the third article which defines the relationship between governor and chief minister is article 167, and the heading of this article 167 is the duties of chief minister. Duties of chief minister with respect to whom? So the duties of chief minister towards this governor. Now what are the duties that chief minister does have towards the governor? And similarly, this article at the central level you had article 78, which defined the duties of prime minister toward the president. So what duties prime minister and chief minister does have with respect to the president and governor? So there are two duties. The number one, chief minister does have duty to furnish all the administrative information, that how administration at the union, so at the central level, how the administration is being run by the union government, that information needs to be shared by the prime minister periodically and proactively. Even if he is not seeking, it is the obligation on the part of prime minister to provide that information. And at the state level, similarly, article 167 puts this duty on the chief minister, that even if he is not seeking that information, you need to proactively, try to understand the meaning, proactively provide that information. It is your duty, because the language of article 167. If you Google, rather we have put up this slide as well, but I am explaining so that I need not to explain this in another slide. In the prime minister ministerial lecture, we have explained this in very good manner, and so I will not describe all these things on next 3 slides. So on the next 3 slides there has been explanation of all these 3 articles, but I am not going to explain that, considering that you would already have watched that prime minister lecture, but still I am briefing you here. So it does have, article 160 does have 2 clauses. In the first clause, it has been mentioned that chief minister will proactively provide or furnish all the information regarding the administration of the state, that how you are handling a particular issue. If in UP you have this Kanpur shelter case recently unearthed, right, and if there is major media outcry, if that is a major issue, right, then it is the duty of this chief minister Yogi Baba that he will be providing that information to the governor of the UP. So that is one example. Now what in case this chief minister, for the political reasons, because no elected government today is ready to share the power with these constitutional functionaries like governor or the president. So constitution does have provision for that as well, that if for the political or electoral reason, because again as I told you that no elected government would like to share their power with the ceremonial, with the titular heads, right. So in that case, constitution does have this provision that in the second clause it has said that okay, in case if this person is not providing you information, in that case we are empowering you that you can seek that information, that you can call this chief minister, you can dial prime minister at the central level as a president, or as a governor at the state level, you can dial chief minister office and you can ask that, hey, on this particular issue I need information, right, and you can, that can be compelled. Although there has not been any situation where this has led to the constitutional crisis, although in 88 around at the central level, one situation between Gyani Jail Singh and Rajiv Gandhi government had emerged, where Jail Singh was hell-bent that no, on the issues like Bofors, on the issues of corruption, right, he was demanding some files, he was demanding, seeking some information, and immediately after 1984, due to those killings of Sikh, kind of cold war was going between Gyani Jail Singh, that was president, and Rajiv Gandhi, that was he was prime minister. So a kind of cold war was ongoing from 84 to 88 around, right. So this this Cold War culminated finally into 88 to the extent, and mind you that this president was exercising power that has been extended to president under article 78, I am wrong, right, this corresponding article is 78, right. So under article 78 to the power that has been extended, that he can seek the information regarding, if he is not providing information proactively, so he can seek the information. So using this article 78 to, he was almost about to dissolve the Lok Sabha. He is going to suspend the government at the central level. It was only after that the opposition leader led by Atal Bihari Vajpayee ji met Gyani Jail Singh, and they persuaded that, see, this are very rarest of rare power that should be exercised, only into the rare circumstances, and it was only when this opposition delegation of opposition leader met, that the Jail Singh was finally persuaded and he calmed down, right? Thereafter Rajiv Gandhi also met. So, and it was this political situation or the constitutional crisis situation was resolved. But let me tell you that this is a power that has been extended under Article 167, 2 and 78 to the president and to the governor respectively, that they can seek that information, right? So I hope enough of the discussion on the powers of chief minister and powers of the governor under these three articles. So this has been put in detail on the next three slides. So you have this Article 163, what is the power of chief minister, then Article 164 and then Article 167, right? So he can proactively, in the first slide you can see that it is the duty of chief minister to provide the information. It is the duty of chief minister. In case if he is not providing, if in case he is not communicating, then this governor can ask, and this is simply a copy paste from the prime ministerial chapter. Dude, it's been very long, can we have a cup of coffee? Come over to my office and don't forget to bring those files that I have been seeking or you have not been sharing very long, right? So that was the explanation of Article 167. I hope you would have understood. So the powers of the chief minister with respect to his cabinet colleagues, the relationship between chief minister and governor, or you can say the powers of the chief minister, you would have understood. And the third category of power that chief minister does have with respect to the house or houses, or you can simply say the state legislatures. So with respect to the state legislature, it is the chief minister who advises governor to summon, prorogue both the houses. So in case of bicameral legislature, both the houses. In case of unicameral legislature, so there are 6 states which does have bicameral legislature, and then there are 22 states which does have unicameral legislature, right? So it is the duty or it is the responsibility of chief minister that he is going to advise governor to issue this summon notification, to ask them that, hey, now prorogue notification can be issued, right? And governor will work accordingly. I hope you know the meaning of what you call summon and prorogue. So along with this summon and prorogue, there are another two tools, that is called adjournment and adjournment sine die, right? So once the business of the house is over, so let us try to understand that who will announce this adjournment sine die. So it is the function. So once business of the house is over, in that case, leader of that house will suggest the speaker. So in case of lower house, in case of assembly, speaker will be suggested by this leader of the house that, hey, business from our assessment, because he is part of the government, right? So he is going to suggest that, hey, business from the our assessment for this particular session is over. Now what you can do is that you can announce the adjournment sine die. I hope you do know the difference between adjournment and adjournment sine die. Adjournment is for a temporary period, suspension of the business of the house for a temporary period, that is for like 3-4 hours or for 1-2 days or 3 days or 4 days, means it will be communicated to the members by the speaker, right? In the assemblies by speaker, and in the upper house legislative council by the chairman. So the meaning is that the adjournment will be for a definite period. It will be defined that, okay, we are suspending the business of the house for so and so reason, for these number 3 days, 4 days or 3 hours, or until the lunch we are suspending. The meaning of adjournment sine die is that the business of the house is over right now for this particular session, and the house is being adjourned for indefinite period, and this decision, this call will be taken by the speaker in the assembly and the chairman in case of legislative council, on the advice of whom? On the advice of leader of that particular house who is part of government, right? But in this case, when so once adjournment sine die has been announced by the speaker of assembly, thereafter this prorogue notification will be issued by the governor, but this time on the advice of chief minister. So I hope what is the role of various, what is the role of leader of the house, what is the role of chief minister, what is this adjournment, what is this adjournment sine die, what is this prorogue, when this prorogue will be issued, when this summon will be issued, right? whose advice governor will work on while issuing this summon and prorogue notification would be clear to you. Now let us move to the second point. He recommends, means chief minister does have power that he can recommend governor to dissolve a particular assembly, right? He does not have power to ask or to suggest governor to dissolve this legislative council, that is upper house, because this is a continuing house. So with regard to the assembly, chief minister does have power that he can suggest governor to dissolve the assembly. But mind you, again this point we had discussed in prime minister lecture as well, and because it is important I am discussing it now as well. So suppose, see, this advice will be heeded by the governor. So suppose as a chief minister, if I am going to governor that, hey governor, can you dissolve this house, right? I want that. So this device will, this advice will be heeded by the governor only when I does have clear cut majority. Suppose there is a situation, so suppose Madhya Pradesh example I am taking. So in Madhya Pradesh, a time back, around 4 or 5 months back, when this there was shift of power from Congress to the BJP, Congress had been suggested by the Supreme Court to face the floor test. Rather, not Supreme Court. Supreme Court came on a later stage. So suppose governor of the state is feeling that a particular government is running in minority. In that case, governor can suggest that, hey, can you go to the house? Can you seek the confidence of the house? Now, this particular government, which has been running from last 2 years due to the political defection, suppose 4 or 5 MLA has defected to some other party, or they have withdrawn their support from the government. Now, this is running in minority and he has been asked to face the floor of the house and seek the confidence. Now, he is anticipating, this government is anticipating that I may not get the majority mark. In that case, can he suggest the governor that he dissolve the house? No. If in this situation, when he has been asked to seek the confidence and in anticipation that I might lose, if he is suggesting that dissolve the house, in that case governor will not pay the heed of that particular leader or that particular party, right? The only situation where this governor will pay heed to this recommendation when this party who is running the government does have clear-cut majority. So it has happened at the central level. If you remember, this government led by late Sri Atal Bihari Vajpayee was completing his term in 2004, but they had preponed the election because they were in 2003 last itself they started feeling that because of their various political stands or various development measures that they had taken, they could win in 2003 itself, right? So they had suggested the president to dissolve the Lok Sabha prior to this 2004 itself. An election was held. So only in the situation when Council of Minister or Chief Minister does have clear majority, only in that situation governor at the state level or president at the central level is bound to consider their advice. In none other situation, when they do not have the clear cut majority, in that situation governor is not bound to pay heed to their advices. I hope this point would be clear to you. There are certain 4 important articles with respect to this chapter, that is article 163, 164, 166. So all these things we already have discussed. 166, duties of chief minister with respect to the governor, we just discussed. Article 166, conduct of the business of council of minister. 164, council of ministers are appointed by the governor, and council of ministers, there shall be a council of ministers to aid and advise governor in exercise of his functions. So these are important articles, at least these 4 articles with respect to this chapter that you must remember, right? If again I am repeating that equivalent article with respect to this is article 74, 75 and 78, right? So these points you this 77, right? So these 4 articles at the central level and these 4 articles at the state level you must remember, and the correlation as well, right? If you remember when we were discussing the governor's chapter, right? So the first slide was something called rule of 89, right? If you could remember this rule of 89, there would be no problems in the correlating the articles of the state level and the central level. You simply has to add article. If you could remember these 4 articles, you can just follow this rule of 89 and you can remember corresponding article at the state level as well. So I hope these important articles you would have clarity on. Now we are wrapping up this lecture with 4 or 5 MCQ that you do have to attempt. So the first MCQ, second MCQ, third MCQ and fourth MCQ, one more MCQ will be there. So fifth MCQ. So these are the 5 MCQ that I expect you to attempt. So until we come up with lecture on Council of Minister, till then, bye bye.